Thank you for joining us for 3Bs on the Law podcast, hosted by Trisha Barita, Camille Canali, and Susan Dawson. Disclaimer, this podcast is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Also remember, laws change or they differ by jurisdiction, so this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you.
Hi, everybody, and welcome to this week's episode of 3Bs on the Law. Trisha unfortunately couldn't join us today, but we have asked our good friend Carena Lemons to fill in for her today. We're really excited to have her here. She's a North Carolina B, Honorary B for the day. She runs an employment law firm called the Lemons Law Firm. And she also, I have to mention this, she also is a wonderful actress and producer. So without further ado, I'm going to welcome Carena to our talk.
Carena. Hey, ladies, fellow bees. Good to see you. Good to see you.
Join us.
Thank you for having me. This is really, really exciting. Looking forward to having fun with you.
And Susan and I may have had a slight ulterior motive in inviting you here today because we know that you do plaintiff's work. And as you know, Susan and I mostly represent businesses. And so we thought it would be fun to play with someone who represents employees and get your perspective on some of the stuff that's happening right now, especially with respect to COVID.
Yes. Yes.
And there's a lot of it.
Yeah.
And ignore the additional guests walking back and forth in the background. It's the fun of working from home. Yay. I have no one to keep the dogs out.
Well, FYI and heads up, I do steal some of that information y'all provide from the employer's side as well. So
that's okay. But we thought it would be interesting. I know Susan and Trisha and I have done a lot of talking and there's been a lot of discussion about personal protective equipment or PPE. And we wanted to kind of get your take from the employee's perspective on what the expectation is from the employers on what personal protective equipment should be provided.
Yeah. Well, it's going to depend on the nature of the job, right? So in healthcare, you're going to have more protective equipment required, especially if you have that direct care of patients, especially if you have direct care of patients with COVID. So that's even a higher standard there. From a plaintiff's lawyer standpoint, your employees are your best asset. I think I'm biased though. And so you want to protect that asset as much as you can. And you certainly don't want them exposed. You don't want to be exposed to lawsuits. One of the inquiries that I had was there was a nursing home, which is, I don't know about where you guys are, but here in North Carolina, they have some of the highest incidences of the COVID-19 virus. And so I had an inquiry in regards to a nursing home that did not take precautions for this employee. And this employee's spouse had contacted me because she had contracted COVID, but they wanted her to come in to get a COVID test by them.
Oh, wow. Interesting.
And so when it comes to risk, I am very conservative. So I'm like, red flags, like that is crazy. They're opening themselves up for a lawsuit. So if that was one of those, we're doing some free hotlines, COVID hotlines through our bar association and one of the news stations. And so, unfortunately, it was one of those call-in things and I didn't get a chance to really get more information from them, but, I hope that she has recovered and she's okay. But those are the types of things that I'm seeing are, employers taking risks like that, employers, being resistant to teleworking. Maybe there have been some issues and concerns regarding that employer's productivity or behaviors in the past. And they're wanting to know, like, do we have to allow them to telework? Can we require that they come into the office? Can we make further inquiries in regards to why they're not coming into the office? Those are some of the things that I've seen. I've also seen quite a few discrimination cases come in. And unfortunately, when there is this kind of ongoing harassment that an employer is receiving from a supervisor, they just don't want to be there. And so, this teleworking has been a blessing in disguise for some of them, because in certain cases where they've requested telework before and it's been denied, the employer really doesn't. It's harder for them to deny telework at this point. If the job can be done away from the establishment, then they should allow that. And that telecommuting is favored by the Department of Labor, by the EEOC. And so that's something that has been to employees' advantage.
Yeah. So let's break that down a little bit. There was a whole lot going in there.
Yeah, I just kind of run on.
Yeah, but I mean, let's break that down. So I heard, not letting them stay on telework after reopening. I heard discrimination, and I heard not properly protecting employees. And so those seem to be some areas that you're seeing, or at least if the employers need to be on the lookout, those are the areas that employees are calling and complaining about, or asking questions about their rights. So maybe where do you want to start, Camille? Or should we start with
my big follow-up question is, what do you do with an employee who says, I'm afraid to come to work, I've been telecommuting, why can't I continue to telecommute even though the office is opening?
Yeah, I think you should make a further inquiry into why the employee doesn't want to come to work. If the employee is smart, they should say that they have underlying health conditions that put them at risk, that they are immune compromised, because you don't have to be immune compromised to be at high risk. You could have diabetes or high blood pressure and be at risk. So you can just say, I have underlying health conditions, or my partner at home has underlying health conditions, and I have some legitimate concerns about being exposed to the virus. My partner and I, we haven't gone anywhere since March. We order everything in. We have our groceries delivered. We are very minimal. Do we leave the house? And so if an employee was smart, that's what they would say. But most of the time, they're not that savvy in terms of what the legal requirements are. So I want to say they're not that bright, because they are bright. My clients are always bright. Well, just like yours. Your clients are always savvy, and they know exactly how to handle these matters.
But I think it's important. They can't just say that. They have to establish it as well, right? So an employee can't just claim that they have diabetes. Because the next step is the employer can ask for some documentation or medical notes related to that to confirm.
Well, correct? I think that they would probably need, what I would advise the employer or the employee to do is to get a return to work note or doctor's restriction note. So have your physician go in and say, my client must telework because they have been diagnosed with such and such and such, or they are at high risk. So maybe not asking for those medical records, because I think that's overreaching, but asking for the reasons why this employee cannot return to work. Likewise, the employer could provide some type of physician's form, physician's request form, that most of them have that form. And if they don't have that form, take a look at the government's forms. They're big on forms. So the federal employers have some really robust forms for that type of thing. So creating some type of form that the doctor can fill out and say when they anticipate the employee being able to return back to work. And if it's indefinite, then maybe it's something the employer can reassess after some time.
What if if the employee can't perform their duties? Let's say it's a manufacturing client and the employee is needed on the line and they're afraid to go to work. What do you recommend, or what steps do you recommend the employees take in that case?
Well, unfortunately, I would recommend the employee to start looking for other work because, if it's unreasonable, the employer is not required to make reasonable accommodations. So it has to be something that fits with. I think the employer would be able to argue that there are no reasonable accommodations for the work that they do, because they can't put everybody in the file room, if they have a manufacturing plant and it's, 5,000 employees, they can't put 1,000 employees, in the file room.
Oh yeah, that's great advice. I want to move on. And Susan, I know you had a couple questions about discrimination.
Right. I'm wondering, even just what we just brought up. So when you brought up the concept of people wanting to telework because there's someone in their home that is at risk, but the EEOC hasn't come out and stated that is sufficient, right? They've actually talked about the fact that there's someone at home who's at risk isn't necessarily reason that you have to pay them right under like the Family First Coronavirus Act, right? That's not one of the paid sick leave or the expanded FMLA unless the care requirement is there.
Right.
So I think what you're saying when you say that isn't necessarily okay, if someone has a family member in the home that is compromised, that you have to make them telework. It's now we have to look at it. Are we discriminating? Is there something bigger than that, right? When we're telling employees who can telework and who can't, we may have to take things like that into consideration. Is that
right? So if we're going under the ADA, if we're going under either the ADA or the Rehabilitation Act, and the Rehabilitation Act applies to those federal employees, the ADA applies to everyone else. If you're going under the ADA, then there would need to be some type of caregiver. They would need to be a caregiver of that person with that disability, with the virus. If the person with the disability is quarantined themselves and locked themselves in the room, and they've got like their own little mini fridge and they've got like a hot plate in there and they're taking care of themselves, that's a different story. But they would have to at least argue that they are the caregiver of someone who has the coronavirus and that they need to be able to telework. It's going to be difficult because if they are truly a caregiver, they're going to have a difficult time figuring that out unless they have someone that can come in and relieve them from time to time. So it all depends. This coronavirus thing, this is kind of a case of first impression. But ironically, there were already some guidelines put into place by the EEOC in regards to a flu epidemic. And so they've just kind of expanded on those guidelines that they've already put into place. The difference between a flu epidemic and the coronavirus epidemic or pandemic, what did I say, epidemic? Pandemic.
Yeah.
Is that the flu, there's a vaccine. We typically have the seasons. We have seen some pandemics here in our area. I don't know about y'all, but in the fall, we saw a huge rise in the flu in the schools. There were several rounds of influenza A and B, and this other thing they didn't know what it was. I think it was the coronavirus. That was floating around last fall. Physicians were wearing PPP, PPE. They were wearing the PPE.
PPP is a loan program. Totally
the loans. Right. Yeah. Business owners. We know that acronym too.
Right. Exactly. We
So
talk about that more.
The physicians may have been wearing, or at least being clothed.
Right.
Cloaked in the PPP, but they would have been wearing the PPE.
Exactly. Can we get some more acronyms going in employment law area, please?
The ADA,
FMLA, FCRA,
the EEOC, FCRA.
Exactly.
I represent
boy.
a lot of federal employees, and they love alphabet soup because if the more acronyms they use, the smarter they appear. And if you don't know them, they look at you like, you don't know what that is, you know?
So our
Oh,
office
boy.
manager was using
Oh boy.
WFH.
Oh,
And
right.
I kept looking at it for like days. And finally, like in my head, it was like working from hell, right?
Right.
What
That's
yeah.
what I thought it was. What is it?
Working from home.
Okay, it is. Good.
You know, I guess in some cases, maybe same difference, but I was just like, no.
Oh boy.
And, you know, companies and organizations don't realize that they're creating these acronyms and they apply internally, but they don't always apply externally. Other people
Right.
don't know what they're talking about at all
Right.
times.
Right.
So if we say something here like the WHD that you don't know what it is, wage and hour division, then just stop us and let us know. Type in the live comments and let us ask us what that is.
I'll let you know. Right. So, but back to the discrimination. Sorry, because this has been fun. What else are you seeing discrimination wise? Is it in relation to furloughing, layoffs? What else are we seeing other than whether or not someone can telework?
Absolutely. So when it comes to layoffs and furlough, the biggest, the things that my potential clients come to me with is that, only the African Americans were furloughed or only the African Americans were laid off. So I would suggest to employers to take a look at how you're determining who's going to be laid off. Are you furloughing all of your wait staff? Are you furloughing all of your line workers, and all of your line workers just happen to be African American, and all your supervisors and managers happen to be Caucasian? So I would take a look at that, because that would be an angle that we would use to argue some type of desperate treatment claim, and say that yes, they laid off all the line workers, but they don't promote. It's failure to promote. They don't promote any African Americans into managerial positions. So that would be something that I would be looking for.
Oh, that's an interesting take on it.
Yeah.
What about, do you see some discrimination in terms of, especially, I know women working at home and being a caregivers at the same time? I know there's a lawsuit that was filed in San Diego that was in the news here last week, where the woman claims that her boss would schedule, meetings at 12 noon when she's trying to feed her 2 young children, and that her children would be behind her when she was trying to have meetings on Zoom.
I'm hungry, Mom.
Well,
hurry up.
She claims she repeatedly asked for the meetings to be scheduled from 2 to 4 when her children were napping, and her male boss insisted upon, scheduling the meetings at noon when she was trying to feed her children.
Yeah,
and so she made a discrimination claim.
Yeah, I mean,
and
I would look at
facts, obviously.
So the inquiry that I would make of this employee would be, how was your supervisor's treatment of you before you started teleworking? Like, has he always made comments about your parenting system, or your children's constant need to pull you away from work? Or, is he constantly making these types of, sexist comments in regards to you being a caregiver?
Mm-hmm.
I would look at those types of factors. Now, if it just started during the pandemic, then it might be a little bit harder. Well, at least in North Carolina, the employer would be able to weasel their way out of that pretty easily.
Right.
That's what I was thinking. They were going to have a lot of legitimate business reasons for it that weren't discrimination, but this is California, so
it's an example,
I think it's a great example. I do, especially since, and not to interject, but especially since the EEOC has come out and said specifically, you need to be flexible and allow people to have their childcare time at home. Mm-hmm. Right.
And who schedules meetings during lunchtime, like all the time?
And here's the thing,
yeah, right.
Who knows?
People who don't eat lunch.
Yeah, people that don't eat lunch.
So we don't know all the facts.
Yeah.
There could be documented reasons for the termination. We just know what was, I was just using the example because it happened to be in the news, and I haven't read the complaint. I have to admit.
I think it's a good example, though, because
I
I've
would
seen a lot of on the employer side saying, well, they're not working as hard, or they're not as available, or they used to respond to emails so fast, and now it's taking longer. And, what do we want to do? I want to let them go, or what have you. And that's the question. It's not always, it's always directed at females. It's at both sexes is what I'm hearing. But the question is, are they dealing with childcare issues? If they are, then we have to be sensitive to that, because the EEOC has come out and said that that you have to be, right? Even with summer camp time. But I think it's a great example, Kamal. I think that's very realistically what's happening today. I'm not, from the employer perspective, I'm not seeing too many people that are terminating all of the women, or all of the people over 40, or any of the protected classes. But that's the intricacies, right? Are you scheduling all your meetings at times when the women are trying to feed their children?
Yeah.
And if they've got young kids, it's not as easy as people think to feed them at 11 versus noon. It's not.
And I would lay it on real thick as a plaintiff's attorney. I would say, look at this punishment. You're trying to starve her out and starve her kids. I mean, what are you doing here?
Right. Right. It's interesting. I think it'll be a really interesting case to follow. So,
absolutely.
So I know that we're kind of running on a lot of time, and I guarantee we could talk and talk and talk and talk. And maybe we'll have to have you come back so we can talk some more. But my kind of last wrap up question, and Camilla, you might have another last wrap up question. This is just mine, is if there's one thing, because you represent employers as well, right, Carena? Yes. So if there's one thing from the plaintiff side perspective that you have that you could tell employers now that they should watch out for, or they should be careful of, or what is that kind of like one tip? Is there something? I'm totally putting you on the spot, by the way.
No, I would say be sensitive and be document, and don't just create this trumped up paper trail. Literally be specific. Make sure that you are using performance improvement plans. Another acronym for that is PIP. For those out there in the audience, make sure that you're using documenting. Don't wait for the employees' behaviors to stack up. Go ahead and document them as they happen as a correction. And that way, when it comes down to an employer's wanting to discipline the employee or reduce or eliminate telework, then they have documentation to support their reasons for doing that. I think when an employer waits and just stacks everything up in one write-up, it makes it look like a setup. You go back 5 years in one document and say you're fired. And you have no documentation that this employee's work performance was in question.
That's great advice. And with that, I think we leave it there. Carena, thank you so much for coming on today. We really appreciate it.
Thank you for having me. I look forward to coming back and chatting with you again.
Yeah. Good to see you.
Oh my God, she was fabulous.
Oh, I love Carena. It's so good to see her.
We're definitely going to have her back again.
For sure. And I love the whole documentation, because we have a whole podcast on document.
You got it. So
that was great.
Everybody, thank you so much for joining this episode of the 3 Bs on the Law, and we look forward to seeing you next time. Have a great day. Thank you for joining us on today's podcast of 3 Bs on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at 3THREEBsonthelaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice and does not create an attorney-client relationship. Thank you again for joining us, and have a great day.